Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a great show for you today. First, Richard Allen is denied by the Indiana Supreme Court again. Karen Reed was back in court yesterday. I'll explain what it means. The Black Swan trial begins after a last-minute attempt to delay the start. Body cam video shows why a police officer will probably spend the rest of his life in prison. Then a Missouri woman decides to plead guilty to murder. A new judge on the young thug trial, and it sounds like she's going to get things done. How bad would a situation have to be in a car if you jumped out of that moving car? A Missouri woman is released after 43 years in prison for a crime she didn't commit. And then finally, our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and remember you can listen to us anytime on any of your favorite podcasting apps. All right, tonight is Tuesday. Tuesday Night Live begins 6 p.m. Mountain Time today. Please join us. We will talk about all of the cases that you want to discuss. I'll answer your legal questions, and maybe we'll discuss the attempted assassination of the former president. Was it incompetence or an inside job? I don't know. We'll have to wait and see. Anyway, please join us. And a quick note, remember when I put out the request for somebody to get me a t-shirt from the pizza shop where Rex Heuermann bought his pizza that ultimately got him arrested? That's right, the Gilgo Beach shooter. That's right, a subscriber has come through. Thank you very much. The pizza is amazing, but make sure you finish the crust. Remember, that's how Rex Heuermann got identified, through DNA from a pizza box. So thank you for getting that for me. I do appreciate that. All right, like I said, join us tonight, 6 p.m. Mountain Time live. Let's go ahead and get to the docket today for Tuesday, July 23rd. And first on the docket, that's right, Richard Allen. Well, the Indiana Supreme Court has rejected the latest attempt to remove the special judge, that's right, Francis C. Gull, from the Delphi murder case. Now, Richard Allen is obviously accused of killing 13-year-old Abby Williams and 14-year-old Libby German back in February of 2017 in a case that obviously many people have been watching all over the country. Now, he was arrested for that murder back in October of 2022. And last week, Allen's attorneys, Brad Rossi and Andrew Baldwin, claimed in a court filing that the judge, Francis C. Gull, failed to rule on their request for a Franks hearing appropriately. In turn, they then went to the Indiana Supreme Court to have the judge removed for failing to act on the motion. Well, guess what? The justices didn't agree with that request. The Indiana Supreme Court said that Allen's attorneys continued to file new motions, and the justices said that that action waived any relief for Gull failing to respond to the earlier filing. Now, Judge Gull and the lawyers have been unsuccessful in recent attempts to remove one another from the case. Earlier this year, the state Supreme Court reversed Judge Gull's decision to remove the lawyers and denied the lawyers' earlier request to remove the judge. Well, back in May, Allen's trial was scheduled to begin, but that has been moved to October 14th for his start date, and that's going to go through mid-November. He was scheduled for a 3-day pretrial conference on July 30th through August 1st, and that hearing will go over the nearly dozen of different motions that both the prosecutor and the defense have filed on issues regarding motions to suppress evidence as well as other motions. I'd say we'd bring it to you live, but that's right, the judge doesn't want any cameras in her courtroom because, well, it's going to be very, very interesting. All right, next on the docket, Karen Reed's back in court, and she has a new trial date. That's right, the judge overseeing the Karen Reed case set 3 new dates for Karen Reed's retrial during a brief hearing yesterday. Now, the second trial is now scheduled to begin, the retrial, on January 27th of 2025, with a final pretrial conference slated for January 14th. Now, Ms. Reed will be back in court at 2 p.m. on August 9th for arguments on the defense motion to dismiss 2 of the 3 charges against her. Now, the defense attorney said that he has another trial scheduled to begin in Essex County on January 13th, leaving his schedule somewhat uncertain. He raised concerns about the prospect of jumping from one trial to the next with no time in between for preparation. So the judge said, why don't we do this? Let's put it on the docket for the 27th, and let me see if I can make peace in Essex County. And then on the next day, when we come back for oral arguments, we can address the court as to whether there's going to be an issue. Judges do that sometimes. They communicate amongst themselves to try to get things done. Anyway, the judge also offered to talk to the judge to facilitate that scheduling issue. So the reason why they will be back in court for oral arguments is the defense has filed a motion saying, hey, judge, you declared a mistrial somewhat prematurely. Now, remember, neither the defense nor the prosecution asked the judge to question the jury as to whether they had reached a verdict on any of the counts. They all the defense requested a mistrial, and then the judge granted the mistrial. And now the defense says, hey, we've talked to the jurors. We believe, or they state, that the jury found Miss Reed not guilty of 2 counts, and they were hung on the 3rd. And the jurors are a little upset because they didn't realize that they didn't tell anybody. Well, frankly, how would they have known from the letters that were sent from the jury foreperson to the judge? The judge wouldn't have. They just stated, we're deadlocked, which would make one believe they're deadlocked on all charges. They never said, we've reached a verdict on 2 of the 3 counts. So there's a little case law that maybe the judge could enter judgment of acquittal or not guilty as it relates to those 2 counts there in Massachusetts. Frankly, never heard of such a precedent, but the defense cites that in their motion. I am of the view, however, that the defense is the one that kind of dropped the ball here because they did not request a polling of the jury or to find out whether, in fact, they'd reached a verdict on any of those counts. So therefore, those judgments of acquittal never were entered in the record. I don't see how the judge can now go back to do that again. I've been wrong. Not normally, not usually. However, if they in fact do that, I will say I was wrong. But I think that what is going to happen is judges say, no, we didn't do it. The prosecution can go forward. They know what the verdict would have been on those 2 counts, and the prosecution can say, guess what? It's going forward. We're going to take our chance with a new jury. Now, I've said this before, and I will say it again. The only side of a case that benefits from a mistrial is the prosecution. They get to refine their case. They've seen exactly what the defense has, and they get to fix it. Okay? Quick story. I had a case years ago. Horrible gang sexual assault. Horrific case. First trial, mistrial. Second trial, mistrial. It was both 11-1 for guilty. The question was we know we found 2 stupid people in Denver. The question was there a third? Well, my client didn't show up for the 3rd trial, so we'll never know, but everybody else got convicted. So the moral of the story being it never works out well for the defense in a mistrial, okay? I don't think I've ever won a case that's been retried on a mistrial. It only helps the prosecution. So I know the defense was looking for a mistrial, hoping we get to do it again. We get to live to fight another day. But be careful what you wish for sometimes. All right. Next on the docket, the Black Swan murder trial has begun. Opening statements have been given, and testimony has started in the case of a former ballerina accused of shooting and killing her husband back in 2020 in Florida. Now, a jury was seated on Monday in the case of Ashley Benefield's murder trial, who was arrested for killing her estranged husband, Doug, back in September of 2020. Now, Ashley claimed that she acted in self-defense after Doug allegedly tried attacking her the night that he was killed. Now, prosecutors are arguing, though, that there were no signs of abuse, and rather Ashley did as a last-ditch effort to gain custody of their daughter, who was 2 years old at the time. Now, the couple got married back in South Carolina 13 days after meeting in 2016. Ashley moved to Florida after learning that she was pregnant and began fighting for sole custody of their child. She accused Doug of abuse, which a judge never found to be credible. Now, Doug was killed while in Florida, helping Ashley move her and their daughters belonging to Maryland, where the couple was planning to live separately but in the same state. As in all high-profile cases, you got people from both sides. Now, protesters organized by Ashley's pastor, a guy by the name of Mike Brown, showed up to show their support for the former ballerina outside the courtroom. And he says, we are, quote, "We are standing for Ashley." He explained, "We have a group of domestic violence survivors who are standing with us, and we really want to see justice prevail." Well, needless to say, Doug has supporters as well. Doug's cousin, a guy by the name of Tommy Douglas Benefield Jr., who's also planning to testify in the case, stated that we have known the facts of this case from early on. We knew all along he had been fooled. That's because he didn't want to lose a wife and a second child. He did everything that he could. He said Doug, who is a Navy veteran, was just trying to do the right thing. He's just a good guy and made a really bad choice of marrying a woman after 13 days. He did everything he could to put the family together with his daughter on very short notice. Well, on Monday, the defense attempted to delay the trial by 60 days, asking for a continuance and claiming that recent rulings by the court had severely impaired Ashley's ability to present an effective defense. Well, guess what? The judge denied those motions, saying the defense had more than enough time to prepare because, well, they've had 3.5 years. And the judge has already told Ashley, who's out on bond, that she faces a minimum sentence of 25 years in prison and a maximum life sentence in prison if she is found guilty. Now, the trial is expected to last 2 weeks. Now, the judge watched the motions hearing yesterday. The defense, I don't know. I didn't really get what they were trying to say. One, they needed a continuance. Some of it was for courtroom logistics, because the attorney's staff wasn't going to be allowed to sit at the table and they couldn't have a cord that was long enough. It was really odd. And it was kind of a last-minute attempt. But then they also filed a motion for the judge to recuse himself based upon denying the request for immunity based upon make your day or stand your ground in Florida. Now, it doesn't mean they're not going to be able to raise that issue at trial, but the argument was that the judge was biased and prejudiced as it relates to Ms. Benefield because the court had made findings that she did not basically act lawfully under the statute and therefore wasn't entitled to absolute immunity. It's still a question of fact for the jury. And so the argument was, well, Judge, you ruled against her, therefore you can't be fair and impartial. Well, needless to say, the judge denied it. In fact, he didn't even really address it. He just kind of kept moving on and said, all right, well, we're going to get juror questionnaires up here and here we go. So interesting indeed. Should be an interesting 2 weeks. All right, next on the docket. This is not going to end well for this police officer or the police department, and I'm sure they're going to get their checkbook ready. So Sonia Massey ducked and apologized to an Illinois sheriff's deputy seconds before he shot the woman 3 times in her home, with one fatal blow to the head, as seen on body cam video that has been released. Now, an Illinois grand jury indicted former County Sheriff Deputy Sean Grayson last week. He has pled not guilty to the charge of first-degree murder, aggravated battery with a firearm, and official misconduct. Now, the video confirmed prosecutors' earlier account of the moments when Grayson yelled from across a counter at Massey to set down a hot pot of water. He then threatened to shoot her. Massey ducked, briefly rose, and then the officer fired his pistol at her. Now, authorities state that Massey had called 911 to report a suspected prowler. The video shows the 2 deputies responding just before 1 a.m. on July 6 at her home in Springfield, which is about 200 miles south of Chicago. They first walked around the house and found a black SUV with broken windows in the driveway. It took Massey then 3 minutes to open the door after the deputies knocked, and she immediately said, "Don't hurt me." She seemed confused as they spoke at the door, and she repeated that she needed help. She referenced God and told them she didn't know who owned the car. Now, inside the house, the deputies seemed somewhat exacerbated as she sat on her couch and went through her purse. They asked for identification to complete the report before they were going to leave. Then Grayson pointed out a pot sitting on a flame on the stove. "We don't need a fire while we're here," he said. Anyway, Massey immediately got up and went to the stove, moving the pot near a sink. She and Grayson seemed to share a laugh over her pan of steaming hot water before she unexpectedly said, "I rebuke you in the name of Jesus. You better effing not, or I swear to God, I'll effing shoot you in your effing face." He then pulled his 9mm pistol and demanded she drop the pot. Massey said, "Okay, I'm sorry." In Grayson's body cam footage, he pointed his weapon at her. She ducked and raised her hands. Grayson was still in the living room facing Massey and separated by a counter dividing the living room and the kitchen. Now, prosecutors have said the separation allowed Grayson both distance and relative cover from Massey and the pot of water. Now, after the deputy shoots her, Grayson discourages his partner from grabbing a medical kit to save her. He states, "You can go get it, but that's a headshot," he said. "There's nothing you can do, man." He also added that, "What else do we do? I'm not taking hot effing boiling water to the effing face." Well, noting that Massey was still breathing, he relented and said he could get his kit too. The other deputies said, "We can at least try to stop the bleeding." Now, Grayson told the responding police that she had boiling water and came at me with boiling water. She said she was going to rebuke me in the name of Jesus and came at me with boiling water. Not exactly what was on that body cam. Not going to end well. We'll give that officer the presumption of innocence, but don't think that's going to end well for him. Yeah, get the checkbook ready. Next, a woman in Mississippi pleads guilty after they find the victim's body. So a Mississippi woman who pled guilty to killing a man and then dumping his body in the Jefferson Davis County oil field was sentenced to 40 years in prison and a requirement that 35 years would be served before the possibility of parole or early release. Now, the district attorney stated that Sarah Jane Isco, who was 22 years old, was sentenced shortly after pleading guilty to the murder of a man that she shot, 24-year-old Carlson Sistrunk, back in September of 2022. Now, Sistrunk was reported missing back in September of 2022, and according to the district attorney's office and the coroner, the body was found just last week. His body was discovered at an oil well site by a worker who noticed some tire tracks, and the Jefferson Davis County Sheriff said that Sistrunk had been shot. Now, Isco, who was 20 at the time of the shooting, was arrested by the Mississippi Bureau of Investigation back in 2022, and the agency issued a warrant for her arrest for felony taking of a motor vehicle charge out of Rankin County. Well, Ms. Strickland said that Isco became a suspect in Sistrunk's murder after being stopped by an officer while she was driving a vehicle that belonged to Mr. Sistrunk. According to police officers, Sistrunk and Isco had been communicating online and planned to meet one day in person, which is a good segue into why you should go to CrimeTalkSearch.com and sign up for that background subscription service. Guess what? You can cancel at any time. But while you have that subscription, you can do as many background searches on as many people as you desire. And you literally receive the report while you wait. It is emailed to you, and you can check it out. You can see if somebody has a criminal history. Are they on some sort of sex offender registry? Have they filed for bankruptcy? Are they married? Are they divorced? All those things that you need to find out before you start bringing somebody important into your life. So go to CrimeTalkSearch.com, sign up for that background subscription service today. You will be happy that you did. Next, we have a new judge on the Young Thug trial, and I think she's going to get things done. So we have a new judge who's been assigned to the Young Thug trial that's been taking place in Fulton County, Georgia, after the original judge was recused for an ex parte meeting, and the second judge then recused herself. The new judge is not playing, though. She says, "I don't want to get into any substantive arguments today," she said at a court hearing, "but we don't have the parties themselves here." That's right. You got to have all the parties present. Anyway, the first thing that Judge Whitaker did was to make it clear that court would start promptly at 8:45 and end at 6 p.m. daily. That's going to go through Friday nights, and they might be half days depending on Fridays, depending on any tasks at hand. She said, "I'm thinking 8:45 to 6, and when I say 8:45, I mean 8:45. She said that she intends to take the bench promptly. Now, Judge Whitaker also said that she knew some defendants had several attorneys, but if one attorney was present, court would go forward. "I don't want to be waiting around until 9:30, the judge emphasized to all of the attorneys. Next, she addressed concerns raised by individuals associated with the trial. Judge Whitaker stated that everyone is welcome to have water or any drink that they prefer, provided they aren't clumsy and avoid spilling it everywhere. However, food will no longer be allowed in the courtroom unless the court is working through lunch or dinner. No snacking during the trial. If we're working through lunch or it's late or it's dinner time, it'll be okay for the attorneys or the defendants to have food, but not while someone was on the stand testifying. This isn't a movie theater. We're not eating popcorn," she explained. Anyway, Judge Whitaker mentioned that the deputies had informed her that the clothing situation had become somewhat excessive. Apparently, some defendants appear to have a wardrobe full of clothes, which was cumbersome to the deputies to manage. So she said, "Let's make sure it gets whittled down to a manageable amount. There's only 5 days in a week, so even if they had a different outfit each day, that would only be 5 outfits. We shouldn't have 20 different outfits for anyone. Clear out the closet," she said. The judge also banned the use of AirPods in court, noting that they raised concerns for security. Initially, apparently someone suggested they were there to prevent the defendants from getting bored. You're at your own trial and you're getting bored, so you need to listen to music? What the heck is going on? Anyway, the judge said, "Well, we won't be bored from here on out," she noted. She added that if AirPods were needed for listening to interviews or other legitimate purposes, this should be done before court, and the scheduling issues should be communicated to her. The judge also asked the lawyers to conduct court in a manner that minimizes disruptions, though she didn't specify what those disruptions possibly might be. Finally, the judge instructed the prosecution, the attorneys, to provide a list of witnesses and summaries of their testimony. All evidence, especially extensive items like audio or video recordings, must be reviewed and their admissibility determined before being presented in court. Any missing report or discovery materials need to be listed and addressed promptly. Additionally, given the number of witnesses the state plans to call, the judge said made it clear that she expects the actual testimony of witnesses to move along quickly. She said, quote, "I expect you to have your next witnesses ready to go. I don't want there to be a 5-minute pause between one witness getting off the stand and the next witness getting on the stand." The judge is a former Fulton County prosecutor who also worked at the state attorney general's office, and she has been a judge since 2017. The judge went to one of my favorite colleges that I try to get everybody to go to, the College of Charleston, and then she got her Juris Doctor degree from Duke University. Now, this judge is laying down the rules that most judges lay out. As you may recall, the Young Thug trial has been going on for 18 months. It took 10 months to select a jury. The previous judge who was on this case was a clown. He was a joke. Nobody respected him. He didn't hold anyone to account, so why should he? Obviously, he got kicked off for having an in-chambers conversation without defense counsel present when a prosecutor and a witness were in chambers. So like I said, jury selection, 10 months. That's ridiculous. Anyway, at 18 months and counting, it is the longest trial in Georgia history. And obviously, there's been lots of disruptions, including illnesses, the arrest of a juror and a lawyer, the stabbing of a defendant, Shannon Stillwell and various other disruptions. But anyway, we're going to be moving forward quickly on this particular case now, and it may actually be worth watching. When we were showing this, it was painful. But I think this judge, there's a new sheriff in town, there's a new judge in town, and it's going to be moving along much quicker. Next, how bad would something have to be in a car for you to jump out of it? Court records are revealing what caused a woman to jump to her death while in a speeding car in Arizona. Now, the Pima County Sheriff's Department said that William Nathaniel Holloway kidnapped his girlfriend, Deborah Marita, back on July 20th. About 6:20 p.m., Marita called 911 and said that the Mr. Holloway was driving erratically and would not let her out of the car. She also said that they were headed toward Mount Lemmon. According to court records, Mr. Marita could be heard crying and begging Holloway to pull over and let her out. Deputies found the vehicle and tried to get Holloway to stop, but he refused. He was able to swerve and avoid a spike strip, according to the police. And then Marita jumped out of the vehicle about 6:50 and suffered fatal injuries. Now, Holloway was eventually stopped about 7:20 p.m. and was taken into custody. And the speeds were up to about 45 miles an hour in the mountains. Now, the police also noted that Holloway showed signs of impairment and drug paraphernalia that was found in the vehicle. Holloway said that Marita had been living together, but they were having some issues. He claimed that he never saw any of the police when they were trying to pull him over, but admitted that Marita had been asking for him to let her out. Needless to say, he didn't stop when she jumped out. Yeah, bad fact for Mr. Holloway. He said that when Miss Marita jumped from the vehicle, he never stopped. He claimed he took about 20 fentanyl pills. Anyway, Mr. Holloway is facing numerous felony charges, including first-degree murder, kidnapping, unlawful flight from an officer. Holloway has a criminal history dating back to 2008. He has some convictions for armed robbery, third-degree burglary, attempted fraud, and trafficking in stolen property. He won't be doing that again for a while because it's unlikely that he will make the $750,000 bond on the case. Can you imagine how bad someone must have felt, how desperate they must have felt to jump from a moving car? Crazy, ladies and gentlemen. Next, a Missouri woman released after 43 years in prison for a crime she didn't commit. So a woman whose murder conviction was overturned after she served 43 years for a life sentence was released last Friday, despite attempts in the last month by the Missouri Attorney General's office to keep her behind bars. Now, Sandra Hemme, Hemme, who's now 64, left a prison hours after a judge threatened to hold the Attorney General's office in contempt if they continued to fight against her release. She was reunited with her family at a nearby park where she hugged her sister, daughter, and granddaughter. "You were just a baby when your mom sent me a picture of you," she said. You look just like your mama when you were little, and you still look like her." Her granddaughter laughed. "I get that a lot." Anyway, Hemme had been the longest-held wrongfully incarcerated woman known in the U.S., according to her legal team at the Innocence Project. The judge originally ruled on June 14th that Hemme's attorney had established clear and convincing evidence of actual innocence, and he overturned her conviction. But the Attorney General, Andrew Bailey, fought her release in the courts. "It was too easy to convict an innocent person and way harder than it should have been to get her out, even to the point of court orders being ignored," her attorneys argued. "It shouldn't be this hard to free an innocent person." Now, during a court hearing last Friday, Judge Horstman said that if Hemme wasn't released within hours, Bailey himself would have to appear in court on Tuesday morning. That's the Attorney General. He threatened to hold the Attorney General's office in contempt. He also scolded Bailey's office for calling the warden and telling prison officials not to release Hemme after he ordered her to be freed on her own recognizance. "I would suggest you never do that," the judge said, adding, "To call somebody to tell them to disregard a court order? Well, that's wrong." Anyway, Hemme declined to address reporters after she was released. The attorney said that she was going straight to the side of her father, who was hospitalized with kidney failure and recently moved to palliative care. This has been a long time coming, the attorney said, and she was looking forward to her release. Now, the attorney said previously that the delays had caused her family irreparable harm and emotional distress, and there's still going to be a lot of struggle ahead. Now, she's going to need help, noting that she won't be eligible for Social Security because she's been incarcerated for so long. And over the last month, a judge in an appellate court and the Missouri Supreme Court all agreed Hemi should be released, but she was still being held behind bars, leaving her lawyers somewhat puzzled. Well, the lone holdup to freedom apparently came as the Attorney General, who filed court motions seeking to force her to serve additional years for decades-old assault cases based on the Attorney General's action. The warden at the correctional facility declined to let Hemi go. Well, the judge ruled on June 14th that the totality of the evidence supports a finding of actual innocence. A state appellate court ruled on July 8th that Hemi should be set free while it continued to review the case. The next day, July 9th, Horstman ruled Hemi should be released to go home with her sister. On Thursday, the Missouri Supreme Court declined to undo the lower court's ruling that allowed her to be released on her own recognizance and placed her in her sister and brother-in-law's care. The Attorney General responded with another request late Thursday, asking the circuit court to reconsider. Now, Hemi was serving a life sentence at the correctional facility for the 1980 stabbing death of a library worker by the name of Patricia Jensky back in St. Joseph, Missouri. Hemi's freedom was complicated by a sentence she received for a crime committed while behind bars. She received a 10-year sentence back in 1996 for attacking a prison worker with a razor blade, and a 2-year sentence back in 1984 for offering to commit violence. Now, Bailey had argued that Hemi represents a safety risk to not only to herself and others, and that she should start serving those sentences now. Anyway, her attorneys countered that keeping her incarcerated any longer would be a draconian outcome. Anyway, she's out, she's innocent, and why would the Attorney General argue that way? I get it. When you let somebody out or you agree to it, that means the system completely failed. But guess what, ladies and gentlemen? When the system fails, how do you know that it's failed? It's failed when the people there are more concerned with protecting the institution than they are in doing the right thing. True innocent cases usually are found out when somebody leaves the office. Years down the road, somebody finds an exculpatory document, and then they say, hey, we need to turn this over. And then what happens? The institution, the prosecution institution, will do all that they can to defend the institution without acknowledging that they did something wrong. We see a lot of that today. FBI director says, he is there to protect the FBI. Well, no, he should be there to serve and protect the Constitution, not the institution. And if the institution does it so poorly and so badly that it needs to be dissolved, then so be it. That's when you know a lot of these institutions have completely failed and they're corrupt when they don't want to do their jobs and they don't want to defend the Constitution, but their only job is to protect the institution. Next, our dumb criminal of the day. Hopefully you saw our posts that we put on our community page as well as our Facebook page that says you can't fix stupid, but you can give it a court date. Well, that's kind of the dumb criminal of the day. And I know for the people that always comment, stupid shouldn't be a crime. Well, guess what, ladies and gentlemen? I remember learning in law school by one of my very wise law professors. He says the law protects the ignorant. The law protects the ignorant and punishes the stupid. And that's why we have the dumb criminal of the day, ladies and gentlemen, because sometimes the stupid just has to be punished. So please meet our contestant for the day, Gregory Gornell. He apparently was nude, according to police reports, and when he made contact with the police, and he was staying at a facility because he was the emperor's helper. That's right. Mr. Gornell reportedly told the officers that the building where he was living at is an independent living community for residents over the age of 62, and it was under new management, and that the emperor told him that he could stay there. Anyway, Mr. Gornell, who had previously been trespassed from the building, was asked how to get in contact with the emperor. The suspect then advised that such royal outreach could be done through the electric lines. Well, Mr. Gornell was charged with trespass, pled no contest, and was adjudicated guilty of the misdemeanor, for which he will spend the week in custody. Now, Mr. Gornell has occupations listed as a construction worker, according to jailhouse records, and he has previous convictions for cocaine possession, theft, marijuana possession, trespassing, and possession of drugs. Now, given his answers of the emperor gave him permission, the fact that he was naked, and the fact that you can communicate with the emperor makes me believe that there are some mental health issues if it was not drug-induced. Now, hopefully, Mr. Gornell will, in fact, get some treatment that he needs, or someone will help identify any help that he needs if it was, in fact, not drug-induced. Anyway, if it was drug-induced, Mr. Gornell, don't do drugs. It makes you do stupid things, like be in a stairwell naked on a property that you're not supposed to be at. And then it makes you do and say stupid things. So, Mr. Gornell, you are a dumb criminal of the day. All right, ladies and gentlemen, that's all we have for you today. Thanks for joining us. Please join us live 6 p.m. Mountain Time tonight for our Tuesday night live program. Have a wonderful day. And yes, the Constitution matters.